court just changed everything. If you carry, if you train, if you believe the Constitution still means what it says, then what just happened in the Supreme Court affects you directly. A 6-3 ruling didn't just change the legal map, it rewrote the rules for gun owners in all 50 states. From permits to training requirements, from background checks to constitutional carry, it's all now part of a seismic shift. This is more than headlines. This is the front line, and if you don't know these new rules, you could be caught off guard when it matters most. So hit that subscribe button, stay alert, and let's break it all down, one rule at a time, because what you don't know can cost you. Chapter 1. The 6-3 decision that lit the fuse. The Supreme Court's 6-3 ruling dropped like a bomb. It didn't just settle a case, it created shockwaves across every corner of firearms law. The case? It revolved around whether states could force law-abiding citizens through extensive permit delays and mandatory just cause requirements. The court said no, and in doing so, it reinforced and expanded the Bruen precedent from 2022. This ruling is now the new anchor for every Second Amendment legal fight. The decision reaffirms constitutional carry as the baseline standard. Any law requiring proof of need is now on shaky legal ground. The court cited historical tradition as the key test again. It restricts states from burdening fundamental rights with bureaucratic permission slips. With this one move, the court reminded every state the Second Amendment is not a second-class right. It stands shoulder to shoulder with the First, the Fourth, and all others. Chapter 2. May issue permits are on life support. Before Bruen, states like California, New York, and New Jersey used a May issue system for carry permits. Even if you passed the background check and training, they could still deny your permit just because they felt like it. This Supreme Court ruling directly undermines that philosophy, again declaring that subjective discretion has no place in fundamental rights. New York's good cause standard? Invalidated. California's sheriff approval hurdle? On the chopping block. Hawaii and Maryland's restrictive systems? Now under direct attack. Courts must now demand historical analogs, not modern political trends. States now face a legal reckoning. Either revise the law or risk it being dismantled in federal court. And for gun owners, it means your rights don't stop at your county line. Chapter 3. No more delays. The clock is ticking. One of the biggest hidden weapons of anti-gun states? Deliberate permit delays. Some jurisdictions take 3, 6, or even 12 months to process carry permits. That's not enforcement, that's obstruction. This new ruling challenges those timelines by framing the right to carry as immediate and active. You don't wait 8 months to use your freedom of speech, and you shouldn't wait to defend your life. Courts are reviewing time to permit delays as potential violations. Denying timely access is now seen as a burden on the core right. Lawsuits have already been filed in states like Illinois and Massachusetts. Fast-track injunctions are being sought to force state compliance. The clock just became the enemy of anti-gun regulation. If a state drags its feet, the courts may slap it down. Hard. Chapter 4. Mandatory training under fire. Gun control advocates love to mandate extensive training as a way to block carry access. But the court didn't just stop at permits. It also considered whether mandatory classes, range hours, or expensive certification programs could be used to suppress carry rights. The answer: if it wasn't historically required, it's constitutionally suspect. Modern training requirements are now being tested against historical use. Courts are rejecting laws with no 18th or 19th century equivalent. This affects Maryland, California, Connecticut, and other states with strict regimes. Lawsuits are challenging costs, wait times, and certification complexity. This doesn't mean training is bad. It means the government can't make training a barrier to exercise a right, especially not with 500+ class requirements and 6-week waitlists. Chapter 5. Background checks must be instant. The court's ruling didn't remove background checks, but it sent a warning. They must be fast, fair, and consistent. Delays caused by NICS system errors, pending statuses, or state-level holdups now risk violating the timely access requirement. This shifts the burden of proof. You don't have to prove your innocence. The system must prove your ineligibility quickly. Pending NICS checks beyond 3 business days are now under scrutiny. States adding additional background checks face a constitutional challenge. Gun store holds based on discretionary concern may be illegal. Systems like California's 10-day wait and Washington's permit to purchase delays are being re-evaluated. The message is clear. Background checks must be efficient, not punitive. If the system can't deliver results fast, it can't be trusted to gatekeep your rights. Chapter 6. Training mandates. Faced collapse. For years, states have required extra layers of mandatory training to receive a carry permit. But after this ruling, the entire concept is under serious legal threat. The court signaled that overly burdensome prerequisites, even if framed as safety measures, may violate the Constitution when applied too broadly. States like Maryland and New York require up to 16 hours of training now. These may be ruled excessive. California's complicated multi-step process could face a rollback. Some states may shift from required training to recommended training models. The ruling makes clear rights don't hinge on jumping through hoops. The state can't set an arbitrary barrier between you and a constitutional right. That's the real message here, Musline. And it's already shaking up legislatures across the country. Chapter 7. Impact on background checks. No, the ruling doesn't eliminate background checks, but it forces courts to ask, are universal checks, waiting periods, or may-issue policies historically justified? Some justices pointed out that the founders didn't impose preemptive screening to exercise a right. Background checks that delay purchases for weeks may now be challenged under this new standard. Federal waiting periods could face constitutional review if abused. The door's open for lawsuits that argue current systems aren't about safety, they're about slow denial. And under this decision, the government will need strong historical proof to keep these policies intact. Chapter 8. Federal versus state. Who's in charge? This ruling triggered a fresh debate. When state gun laws contradict the Second Amendment, who wins? The court made it clear. Constitutional rights don't stop at state lines. States that continue to pass restrictive laws now risk swift federal judicial intervention. Even federal policies are now being examined under the same originalist standard. Expect to see more cases fast-tracked to the Supreme Court, with this decision acting as the legal benchmark. The balance of power is shifting, not in theory but in real-world cases, hitting the docket every week. Chapter 9. Bruen Reborn. You thought New York State Rifle and Pistol Association vs. Bruen was a landmark? This new decision builds on it and cements it. Bruen said the government must prove a law aligns with historical tradition. This ruling strengthens that standard, making it harder for states to invent modern rules. Laws must now survive strict scrutiny under the lens of original constitutional intent. The Bruen test is no longer just guidance, it's judicial armor. Every case from here on will be judged under this precedent, and any state law that fails to meet it is on borrowed time. Chapter 10. What happens next? This isn't just a legal moment, it's a cultural reset. Gun owners, lawmakers, activists, they're all recalculating their next move. Lawsuits are being filed nationwide using this ruling as the foundation. Pro-gun states are expanding constitutional carry while gun control states are panicking. The ATF's next move will be closely watched, especially after recent overreach. Expect new bills, expect new challenges, expect a wave of transformation across both red and blue states. The Supreme Court didn't just issue a ruling, they fired the first shot in a constitutional revolution. This fight has only begun. The Supreme Court has spoken, loud and clear. Rights don't wait for permission slips, and the burden is now on the government to prove its case. For years, gun owners have played defense, but after this ruling, the tide is turning. If you believe in real reporting, legal truth, and staying one step ahead, hit subscribe. More battles are coming, more victories are possible. And this time, we're not backing down. Stay sharp, stay informed, and always stay free. We'll see you in the next one.